Number 67, John W. Terry et al., Petitioners versus Ohio.
So this is everything you need to know about Terry versus Ohio. We are going to go over what the case is.
The facts in this case are these. This incident occurred at 2:30 in the afternoon, broad daylight, in the downtown section of Cleveland, Ohio. The police officer in this case, one Martin McFadden, noticed two Negro males standing at the corner of 14th Street in the city of Cleveland, where Euclid Avenue and Huron Road intersect. These two streets, if the court pleased, form a triangle at the apex of East 14th Street. The police officer was approximately 100 feet away from where these two men were. He said, well, to tell you the truth, I didn't like them.
Didn't like them?
Yes.
So for this case to continue, for us to continue down the road of this case, you first have to buy that Martin McFadden was a super cop and he predicted a stick-up. We have to start from there to have a case at all whatsoever.
What kind of a neighborhood is that generally in Cleveland? A business neighborhood?
That is our downtown section, the busiest section of the city, Your Honor.
Downtown retail stores and offices and so on?
Yes, Your Honor. And the testimony of the police officer was that there was business as usual in the downtown center of the city. Stores were open. There were pedestrians on the street. The police officers stated that he positioned himself in the doorway of a department store by the name of Rogoff. For a period of 10 to 12 minutes, he observed these two males at the corner. Alternately, each made 5 or 6 trips over to two stores located on Huron Road. He said that he didn't know whether it was the United Airlines store or the Diamond store.
We're going to go over the battle between Reuben Payne and Louis Stokes. And really, Reuben Payne just lays a shellacking on Louis Stokes. And Louis Stokes lays a great big goose egg in the arguments for Terry.
They were standing on the corner conversing. Then, because of their not continuing in the flow of regular commerce, he observed one of the petitioners walk away from the other one and proceed approximately 100 feet west up the street.
Alternately, each made 5 or 6 trips over to two stores located on Huron Road.
He noticed the unusual activity of this petitioner peering in the jewelry store or the airline office there. That was something in the vicinity of the airline office or the jewelry store which excited the petitioner's attention in some manner or in some way.
When you listen to the Terry v. Ohio oral arguments, raw dog, just straight, they're only 1 hour, you'll hear that the number of times that Terry, Katz, and Chilton went over and looked in that Diamond store window, it exaggerates constantly throughout the entire trial. Of course, Louis Stokes never pushes back on this, and the only time it's ever mentioned is when Thurgood Marshall mentions it later in the trial.
He then returned to his companion on the corner, had a conversation with his companion. His companion in turn alternately proceeded up the street and conducted himself in the very same manner, that they alternated in this way 4 or 5 times, that thereupon a third man came from across the street and had a conversation with them. After having a conversation with them, that the third man returned back across the street and stationed himself there, that these individuals then engaged in the conduct which I have described previously, 4 or 5 additional trips after that. Making the total number of trips, they then went across the street. The 3 men came together, at which time they were having a conversation, at which time the officer had concluded that they were casing the establishment for a stick-up.
I don't care if they went back and forth 4 times or 50 times or 100 times. We have the right to assemble in the United States of America. We have the right to assemble. The Colfax Massacre was based on black people assembling. Most of the 1967 massacres were based on black people assembling.
The police officer then says, I then went over to the 3 men. I said to them, I'm a police officer. What are your names? In the first instance, he said, they gave it to me quick. In all other places in the record, he says, they mumbled something. He said, at this, I then reached and got Terry. I spun him around, holding him in front of me. I then began to pat him down. He says, I felt inside of his top coat what felt to be the handle of a gun.
The The cop testified, I didn't like him, so he ran over and grabbed him. That's against your Fourth Amendment right. That's why Terry v. Ohio is the most liberty-stripping ruling that affects us the most. The exact same thing that happened to John Terry, that Martin McFadden did to John Terry, can now happen to you. It's the exact same thing. A cop can look at you and be suspicious of you, and it's always probable cause.
This officer testified further, though, that he felt that they might be casing the place for a stick-up. Then the court then inquired of him specifically if he had ever, and by the way, this police officer had been a police officer for 39 years and a detective for 35 years.
What did they say? They said Martin McFadden had been a cop for 39 years. And they do this big emphasis on it. And so let's go back. He stops John Terry in 1963. So we can go back to 1923 is when Martin McFadden started being a cop, 1924. So what was going on in 1923, 1924? Prohibition. Before Brown versus Board of Education, police were the lynchmen. If you broke the black codes, police were the lynchmen in America.
If the people, the public, would let the police force handle the situation, I believe the integration would not be omitted.
Black people in America aren't even free. So Martin McFadden and all the Supreme Court personnel, they're still being influenced by the Jim Crow Act. So these guys are raised, look at the years they're born. These guys are raised watching that Jim Crow Act that believe that black people are feeble-minded. So Martin McFadden starts being a cop in 1930, and then in 1954, black people are free. And 9 years later, McFadden sees John Terry, says he didn't like how they look. Well, there's no shocker to that. That's not a surprise.
The court specifically asked him if he had, during his 39 years as a police officer, ever previously observed anyone casing a place. He said no, he had not. Asked if he had ever arrested anyone for casing a place. In his 39 years, he said that he had not.
He helps make the case for the state.
I then reached inside the coat and tried to remove the gun. I could not remove the gun. I therefore took the entire coat off of him and then took the gun out of the coat. At this point, he says, I ordered the three of them into the store. As I walked through the doorway, I said to the store personnel, order the wagon. He later explained that ordering the wagon means you are then under arrest.
Just because a cop is suspicious of you doesn't give him the right to walk over and grab you. There's no probable cause. If you understand the Bill of Rights as written, this case should be thrown out right here.
Once inside the store, the three men were ordered up against the wall, whereupon he then searched Chilton. Inside of Chilton's top coat, he also found a loaded revolver. He searched the third male Katz, upon whom he found nothing. He then caused these men to be removed from the haberdashery to Cleveland's police station. When they arrived at the police station, they were then booked for investigation. Sometime late the next day, after having been interrogated the following morning, these men were then charged officially late the second day with carrying concealed weapons. The police officer testified further, reference to questions propounded to him having to bear on the question of probable cause. We asked him, did you know any of these men? No. Had you ever seen any of these men previously? No. Had anyone given you any information regarding them? No. He was then asked what had attracted his attention to them. He said, well, to tell you the truth, I didn't like them.
Looking at someone and saying, I don't like the way you look. What was the attitude and the sentiment of white people in the cities in the early 1960s in America?
I don't like it.
Why not?
Well, I just don't think it's right. If I think people in Mississippi are ready for that, then they'll say they are.
You agree in this?
I think that we were better off before it started.
Well, I think they should have stayed where they was at and just trying to stir up trouble. That's all it is. They should have stayed where they belong.
Well, I don't think none of us like it. I mean, I just think we ought to have open season on all of them.
Well, I don't know. I mean, it's not going to last too long before the people down here get a little antagonized with it, and they're going to take it into their own hands.
Up to the point where he spun Terry around. Had he done anything outside what a policeman might properly do?
No, he had done nothing outside of what a policeman might ordinarily do.
Now, if then at that juncture he had reason to believe they might be armed, Did he have to complete his questioning first, or could he frisk them?
I would say, under the circumstances presented to me, that he did not, under those circumstances, have the right to lay hands on this citizen. And
this would be because you do not think the record shows that he had any reason to believe they had weapons?
No, that he didn't have. I'm saying that the point that you lay your hands on the citizen and you begin to exercise dominion over that citizen on the streets by spinning him around, in order for you to do this, that you must have the probable cause that is required to place a person under arrest, because this person is substantially under your custody, your dominion.
Then you mean he can't frisk for weapons without probable cause to arrest? Is that what you're saying?
Yes.
Pay very close attention. This next part is where we all lose our liberty, where the Fourth Amendment is washed away. Pay very close attention.
In your own court said he still did not have probable cause for arrest. As of this point, we're now at.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with this.
And he didn't get probable cause, so he put his hand on the butt of the gun.
He didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside coat pocket.
No, sir.
Is that right?
No, sir.
Well, when did he get probable cause for arrest?
He received probable cause for arrest when he turned Terry around and ran his hands over the outside of his clothing and feeling a gun in the upper left breast pocket and indicating emphatically at that time that what I felt was a gun, a weapon.
Well, he didn't have it, as counsel for petitioner says, he didn't have it when he laid hands on him and turned him around.
I would agree with, he did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Why?
Because of the nature of the circumstances and protection of his own life.
The lawyer is telling the Supreme Court justice the constitutionality of probable cause. If the white cop is afraid for his life, that matters more than your civil liberties.
Because of the nature of the circumstances and protection of his own life. I find no problem with this particularly because I do not ask for a different standard of probable cause as it may relate to the right to lawfully arrest a person. I think that the quantum of evidence that is basic and essential under the circumstances to establish probable cause for the officer to arrest, for to stop a person and to ask him questions may be somewhat lesser in degree, but by the same token it is probable cause under any circumstances.
That's incredible. That's incredible. He's saying here that if a cop looks at you and he thinks that you could be armed, that's probable cause. That's basic. If the officer feels as though his safety is in jeopardy because he thinks that maybe you might have a weapon, then it's always probable cause. It's always probable cause. And what's the results of making every officer have probable cause in their mind at all times? It's that. That is the result of probable cause right there. You're looking at it. Here's the result of probable cause of an officer being in fear for his life at all times of you. And he says it. Louis Stokes, he nails it. That is exactly our culture today. That's exactly our culture. You're always a suspect.
The same circumstances are indicated.
What do you understand probable cause to mean that a thing may happen?
The Supreme Court personnel are debating back and forth what probable cause is. Probable cause is when you have broken the law supported by oath or affirmation, that you've created a victim. That's what probable cause is. There's no need to kick around what it is. You've broken the law and created a victim supported by oath or affirmation.
And to, if I may put it in my own language, I am saying that there was probable cause for the officer to interfere with their freedom of action at this point.
Well, that's what I say.
Such interference with their freedom of action is not in a significant way at this time.
Well, that's what I understood to be your argument from the use of probable cause. Then what you're really doing is saying you don't have to change the labels. Still probable cause, and it's still an arrest, but an arrest for the purpose merely of asking a question, who are you and why are you here, is a different thing from an arrest for the purpose of taking a station house to book them for a crime, you know?
Do you hear what they're doing? They're trying to normalize that police should be able to run up and grab you if they're suspicious of you.
Under Ohio law, I could not agree with this concept, because under Ohio law, the definition of arrest is by statute.
By what?
Statute. And it contemplates...
Well, forgetting Ohio law for a moment, how about for the purposes of the Fourth Amendment?
For the purposes for the Fourth Amendment, it would be reasonable action on the part of this officer, and if...
Well, I thought you agreed with Justice Black before that really reasonable action and probable cause are pretty much synonymous terms.
The Supreme Court changed the meaning of words to create the word detained, because seized is already in the Constitution. It means arrested.
There was a touching...
What's the difference in seizure and arrest? You may seize him because you seize something tangible, but that's not what you're talking about in the seizure of the Fourth Amendment, I thought. I thought it was an arrest, an appearance of arrest.
It is arrest that I understand that we are discussing in this matter.
Well, an officer could very easily turn a man around without arresting him.
I agree with this, and this is the position that I take.
It might not be easy, depending on his size.
That he could very easily turn the man around, and some may term that as a seizure.
KKK member Hugo Black is trying to argue that seizing you is not arresting you if it's not for the intent to take you to the dungeon. You're really not seized unless you're taken to the dungeon. He's trying to say, well, that's not what it means constitutionally. He's a Supreme Court justice supposedly standing up for our civil liberties.
But I would not term it as a seizure of the person himself unless he has the intention of taking that person into custody, even though he may lay hands on him at that particular time. The first seizure of the person was at the time that he ordered them into the store.
You mean when he took Terry and swung him around, there was no seizure of the person?
I think there was a temporary detaining or interference with his person.
He had his hands on him and he switched them around. Surely there was no seizure of the person.
But here again, we're dealing in simply semantic words.
No, I'm asking, that word's in the Fourth Amendment, isn't it?
Agreed that it is, sir.
Play that back again. Listen to what they're doing. They're changing the definition of detained. Because when detained means seized, he says, isn't that word in the Fourth Amendment? Against unreasonable searches and seizures? But now detained doesn't mean seized in what world? At the Supreme Court. At the Supreme Court. Because if you've been seized, then you've been arrested. And you can't be arrested on reasonable suspicion. You have to be arrested on probable cause.
That the defendants were conducting themselves suspiciously, and some interrogation should be made of their action. 5, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
The Terry laws that we live under today were not written by a legislator. Congressperson writes a bill that's a law, and then the president signs the law into effect. This is our constitutional process. The Terry laws were not signed into effect by the President of the United States. That's not what happened. The Terry laws that we are forced to live under today were written by a Cuyahoga County trials judge named Bernard Friedman.
The trial judge made these remarks. A police officer cannot, as far as this court is concerned, and will not be permitted to stop and frisk an individual simply because he has a suspicion, a mere suspicion, unless there are reasonable circumstances justifying the frisk. When the circumstances justify, and there is reasonable suspicion, and for his own personal protection, he may frisk to determine if there are weapons for his personal safety. The officer assigned in the area which he had been placed, doing the job he had been doing, and had reasonable cause to believe and to suspect.
Probable cause is not probable cause to see or probable cause to believe. That's not possible. How can probable cause to see be supported by oath or affirmation? The cop swears, he promises that he believes he was in danger. So your civil liberties have to go.
that the defendants were conducting themselves suspiciously and some interrogation should be made of their action, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
This next part is where the Supreme Court personnel will inject that this entire thing is about officer safety.
And here there is no suggestion, is there, that the policeman had any basis for fear as to his own safety? Am I right that there's nothing in the record that indicates
There's
that?
nothing in the record whatsoever.
I don't understand your answer to Justice Fortas when you said there's nothing in the record to indicate that the policeman didn't have concern for his own personal safety, because I thought he said that based on his intuition, he thought these people were casing a place in order to rob it. Isn't that what he said?
This is what he said.
Well, presumably then they would be armed, and the minute he walked up and talked to them, he would quite reasonably be concerned for his own personal safety, I should think.
Well, police officers are very often in position where they might not be able to make an actual arrest, but they are in a position of great danger. And where they are in a position of great danger, are they in a position to protect themselves from violence by looking into the situation to see if anyone is armed to do the violence?
Yes, Mr. Chief Justice, he certainly has a right of self-defense, and he has a right to protect himself.
Just atrocious. Listen to Louis Stokes.
Whether with or without reasonable cause, he thought or suspected that these were armed robbers about ready to hold up a place. And I suppose if you walk up to such people and begin asking them embarrassing questions, you might have some little concern for your safety if you bona fide believe that they have weapons on them. Now, that much is in the record, isn't it?
Yes, sir.
No, is that so? Excuse me, but is that so? Does the record show that he thought these men were armed before he put his hands on them?
Yes, he says, after he says that he thought they might be casing the place, and I felt that they might have guns. He
testified to that, but
yes, he did.
Don't you think he'd be justified in the first instance in confirming whether or not they did have weapons before he went on further to interrogate? On the premise that it was reasonable for him to think that they had weapons.
Well, take a situation of this kind where a police officer sees someone acting very peculiar. Might not be in connection with any information he has about any crime. Maybe the person is abnormal mentally. Maybe he thinks he's insane, and he wants to talk to him, but the man shows indications of what he thinks of violence, and he wants to be sure that he won't be attacked when he goes to talk to him. And he goes up to speak to him, and also ascertains whether he has any weapon on him. Did you think he had a right to do that? As a matter of probable cause that he might be injured himself if he doesn't take precautions.
The average police officer would do this under these circumstances. If he felt himself to be in any type of danger, that he would conduct a search for the purpose of protecting his own life in a possibly dangerous situation.
You don't tell the Supreme Court that you're arguing that police shouldn't have the right to run up and grab you and then say, well, this is what a police officer would probably do anyway.
Mr. Justice, I'm sorry if I'm giving you the impression that the police officer cannot ask him a question.
I said can ask him a question, but cannot get an answer and do nothing about it.
He can arrest him if he chooses.
He can arrest him. But suppose he doesn't choose to arrest him.
Then
suppose he wants to do something short.
And I don't think he has that right.
If you read a little biography on Hugo Black, he said that he left the KKK. This is him in 1968. Listen to his perspective and then try to apply his perspective from a Bill of Rights perspective.
Then the man can go on off, not answer questions, because the officer doesn't have at that time sufficient amount of evidence to make the case of probable cause of guilt of committing a crime.
That's precisely what I'm saying.
Hugo Black cannot believe that a black person doesn't have to answer to a cop. That he doesn't think black people have a Fifth Amendment right. His entire life they haven't had a Fifth Amendment right. It's a shocker to him to hear that black people would not have to answer questions to police. Hugo Black is born in 1886, 10 years before legal segregation in Alabama. There's 16 lynchings in Alabama before he's 10 years old. And then in 1896, when he's 10, legal racial segregation begins, the beginning of Jim Crow laws. And what has Hugo Black seen his entire life in Alabama? The Jim Crow Act, which means black people are feeble-minded. Their brains haven't evolved all the way. He's the senator of Alabama from 1927 to 1937. Hugo Black is appointed by Franklin Delano Roosevelt in 1937. And from 1937 all the way up until 1964, Hugo Black has not applied civil liberties to black people. The Supreme Court has not applied civil liberties to black people. So in 1968, that's the reason why you hear Hugo Black saying the things he's saying. Of course black people have to answer to police. I mean, go back and listen to what he says here.
He wants to do something short of a list, but cannot get an answer and do nothing about it.
Suppose he wants to do something else. What is that? What do you mean? What do you mean do something else? What does that mean exactly? What does that mean exactly? What does that mean exactly, Hugo? What do you mean by that, Hugo? Hugo, what do you mean by that? What do you mean by that? Well, we know what he means by that.
I said can ask him a question, but cannot get an answer and do nothing about it.
You can't talk about Terry versus Ohio unless we talk about the Warren court. Earl Warren is facing impeachment by the police. They're picketing up and down the freeways saying impeach Earl Warren because he passed Mapp versus Ohio, which is the start of the exclusionary rule, that police can't just run roughshod over your civil liberties and then present evidence. It's called fruit of the poisonous tree. They got evidence off of you by violating your civil liberties. Mapp versus Ohio stopped that, and the police hated him for it. They hated Earl Warren for doing that. You can hear it when he talks. You can listen to his voice during the Terry trial that he is taking a dive, essentially.
Folks, I wonder if that's going to be broken down a little. I wonder what you would say to this. Of course, a police officer does have the right to investigate a crime. And this police officer, in this instance, had the right to investigate crime.
What was John Terry's crime? What did he do wrong? He was walking around on the street in the daytime talking to other people. It's 2:30 in the afternoon. He's walking around on the street speaking to other people. And they had a conversation. And then he went over and talked to this man. And they had a conversation. And then he stationed himself over there.
He did see what one might well say were suspicious acts on the part of people whom he thought might be preparing to commit a crime. He had a right, did he not, to pursue that farther, to determine whether or not he would have probable cause, perhaps for an arrest.
He said that police have the right, do they not, to walk up to you as you're minding your own business and investigate you. No, Earl. No, they don't. And why does he think that way? He's born in 1891. Earl Warren is supposed to be the defenders of our civil liberties, our right to be free. And instead, he's saying, don't police have the right to walk up to you and question you on the street? That's what he just said.
Pursuant to that, he went to talk to these men. Now, because of the nature of the crime, that he suspected a robbery, he felt that when he went into the company of these three men against himself alone, that he was in a dangerous position.
No, McFadden never said any of that, Earl Warren. You did. You made that up. You made that up with the other white Supreme Court justices. He never said he was in fear for his life. It was the middle of the afternoon on Halloween. There were hundreds of people around. McFadden never feared for his life. You guys created that. You made that up. It's not in any transcript. McFadden never says he was in fear from his life from three black guys. It was two black guys and one white guy named Katz.
And that therefore he had probable cause to see if they had weapons on, not because he had probable cause to believe they had committed a crime, but because in investigating the matter, he had probable cause to believe that his life was in danger.
I think it's important that you understand what probable cause is. Probable cause is when you have broken the law. That's what you can get arrested for. Probable cause supported by oath is when a cop sees you break the law. Or you've created a victim out of someone, you've assaulted them, and they called and they're swearing by oath that you committed probable cause and you broke the law. I just want you to understand, probable cause is when you have broken the law. You crossed on a red, someone called and said that you assaulted them. Earl Warren saying that the cop has probable cause to see is actually impossible. The words don't make sense. He's making things up as he goes.
Under those circumstances, would you think that he did or did not have a right to ascertain whether he was in a position of danger by seeing if they had weapons?
Well, only if we're going to relax the standard of probable cause as we know it under the Fourth Amendment.
As you can hear, Earl Warren is doing absolutely everything to work against our civil liberties to be free. He's working on the side of officer safety that was never brought up. McFadden had zero fear of those guys on the street. It was broad daylight. He felt completely entitled to walk up to them and bully them and push them around. It was never about officer safety, so it's astonishing to listen to Earl Warren push this argument for officer safety over your civil liberties, because the functionality of the Supreme Court is supposed to be to defend our civil liberties at all costs. Defend the civil liberties that are your God-given rights. Listen to this next part carefully. Thurgood Marshall is going to give the best arguments there are as to why this case shouldn't even be in court. And then he's going to destroy Martin McFadden. He's going to destroy his character. He's going to destroy his ability. He's going to destroy everything about Martin McFadden. You have to listen carefully. And then Thurgood Marshall will vote for Terry Lawz because Earl Warren is one heck of a leader.
Well, Mr. Payne, in this case, this arresting officer testified, did he not, that he had never seen anybody case a joint.
That is correct. He did so testify.
He also testified that he'd been on that same area for some 30 years doing the following things: checking for pickpockets and shoplifting.
That is correct.
So where did he get his expertise about somebody's about to commit a robbery?
I think that he would get his expertise by virtue of the fact that he had been a member of the police department for 40 years. And by being a member of the police department for 40 years, I'm quite sure that even if by osmosis some knowledge would have to come to him of the various degrees of crimes.
Now we get intuition by osmosis.
Not at all, sir. Not at all. Not at all. I did not mean, I didn't mean to imply that, nor did I mean any disrespect by so using that particular term. I think that, for example, if I, as a lawyer, am around a particular office for a number of years, that I certainly must gain knowledge about various concepts of law that may come about from time to time.
There are exceptions to that.
I would agree with the court in these circumstances also.
It's a funny joke, right? The thing is, though, Reuben Payne is correct. Reuben Payne is spot on in his analysis of learning policing, being on the job for 40 years. Remember, Martin McFadden's job up until from 1924 to 1954, 20 years, was to enforce black codes, which meant to instill fear in the black community and to be suspicious of black people and to arrest them. After 1954, there's a no man's land from 1954 to 1964. In 1963, Martin McFadden says he's suspicious of John Terry. He doesn't like how he looks. What had he been doing for the 20 years before 1954?
Well, seriously, Mr. Payne, the point is that the only thing he noticed was a man leave from position talking to another man and go across the street, look in the window, and go back.
I disagree.
Now, number one, you'll agree that everybody that looks in a public window is not casing a joint.
Agreed.
But they did do it twice or three times. How many times?
It's
not too clear to me in the record.
May I then, in response to the Justice's question, indicate, first of all, and clarify this. His testimony was not that he didn't like them. His testimony was that he didn't like their looks. Now, I don't think that he meant by that any reference to pigmentation or anything else.
And anyone with two eyes in his head and was
roughly normal vision can look around him and see that there's a vast and permanent difference between the white and colored people. That, as Abraham Lincoln so wisely said a number of years ago, would forever prohibit them from living on terms of equality in the same society. That, just in a nutshell, is the reason.
I think that he meant by that, when we take the entire record into consideration, the fact that this was in a downtown area.
But didn't your own court say they still did not have probable cause for arrest? As of this point, we're now at.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, well, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with this.
And he didn't get probable cause till he put his hand on the butt of the gun.
Listen to the argument that Thurgood Marshall puts forward. He pretty much says that Martin McFadden's a blithering idiot. A beat cop in the same place for 30 years. Thurgood Marshall then votes for Terry Lawz.
The court then based its decision upon Kerr versus California. The court said that Kerr decision did not preclude the states from developing workable rules in order to bring about effective law enforcement in the states.
The court based its decision on the Kerr case that did not preclude the states from creating workable rules for law enforcement in the states. What does that mean exactly? Let's examine what the Kerr case says. The Kerr case uses common law from the 1600s that allows police just to knock, knock, knock on your door and then come running in. Why did we have to invoke common law from the 1600s in 1963? How come that had to happen? Why did that have to happen? I don't understand that at all. You figure that if we had to invoke common law to allow the police to knock and announce and come running in your house, it would have been during Prohibition, when we doubled the prison industry. It would have been during Prohibition, wouldn't it? Knock, 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 announce, and then just come running in your door. So if the court based Terry v. Ohio off of the Kerr versus California decision, how come it took 200 years from 1776 to invoke common law to allow police to just knock, knock, knock on your door, say police, 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 and then just come running in? This is a quiz. How come? Why does that happen in 1963? It's plain as the nose on your face why. If this isn't your first clear understanding that the Supreme Court has put forth racist laws, then you're not paying attention. I know that this is the fact. You explain to me something, please. I'm sorry I get excited. Explain to me where in the Bill of Rights it says that. Explain that to me. Where does it say that the police can just knock, knock, knock on your door and come running in your Bill of Rights? Doesn't it say that you're supposed to be secure in your home, in your house's papers and effects? Isn't that what the Fourth Amendment says? The Kerr case is the first real example of understanding institutional racism.
Our Court of Appeals, in affirming the decision, stated that a policeman may, under appropriate circumstances, reasonably inquire of a person concerning his suspicious on-the-street behavior in the absence of reasonable grounds to arrest. Our court admitted that in all probability this will lead to abuses by the police, but then went on to say that the court would deal with the abuses as they arose before the court. The court stated further that this, of course, was just a minor inconvenience with the personal liberty that is guaranteed, and that therefore each citizen ought to be willing to give up this amount of his personal liberty in order that they might have effective law enforcement in the community.
Bernard Friedman of the Cuyahoga County Trials Court decided for all of us that we should be willing to give up a certain amount of our civil liberties for effective law enforcement. No, I didn't agree to that, and I don't agree to it now. I don't agree to any of it, because we can see now that the words that Bernard Friedman wrote have led to an outright police state, prison state in America.
What are the reasonable cause circumstances that existed in the minds of the officer at that particular time?
What are the reasonable cause circumstances that existed in the officer's mind? That's what our Bill of Rights says. That whatever the officer believes in his mind about you is going to be the determination of whether or not you get your civil liberties. You can't walk down that street right there, because if that cop thinks in his head that you're bad, you're going to be detained.
One, we have a police officer that was in his particular area, on duty, and his duty is to maintain law and order. His duty is to prevent crime if he can so do.
These three police commissions right here, the Wickersham, the Mullen, and the Knapp, they say the police are ineffective in preventing crime, that they don't really work as crime preventers. And at the highest number throughout the history of policing, 4% of time they prevent crime, 4%. How many times are they the organized crime? Most of the time. That's how often the police are involved in crime, when they are the organization of the crime. But yet John Terry can't walk around on the street. It's just the black codes extended is all it is.
Secondly, he has 39 years of experience herein. Fourth, the observations of the suspicious activity which he observed, which may be determined as pre-detention conduct. 5, he concludes from the observation and the conduct of these men that a crime of violence with the use of weapons is to probability may be committed under these circumstances.
What did he do wrong again? He was walking around on the street talking to other people? And that's suspicious activity?
6th, he decides to investigate and to interrogate, and the record indicates and shows that at this particular time, why did you go over to these men? I went over to them to ask them some questions.
No, he didn't go over there and just ask John Terry a question. He had every right to ask him a question. He went over there and grabbed him, violating our constitutional rights to be free. And now, because of the John Terry trial, any cop can run up and grab you. Because of this trial that was 100% based on race.
8, when he asked their names, he received this mumbled, incoherent response, which further gave rise to the circumstances that he had concluded previously that a stick-up was possible here. At this point, taking into consideration the nature of the crime which he has concluded, a stick-up, and the use of weapons as they are characteristically used in a stick-up.
Remember what I said. This case can't continue unless you first believe that Martin McFadden is a super cop and he predicted a stick-up. That's not what was going on. The truth is, white people didn't want black people hanging around the city. But that's not the point constitutionally for you and me. I have every right to look however I want. I have every right to walk around the streets and talk to people all day long as I don't commit probable cause supported by oath or affirmation.
There is only one course of conduct then open to a prudent police officer, and that is to frisk or pat for weapons for the protection of his life. And this is why we considered in the interest of safety and the public welfare in the state of Ohio.
This was not for the good of the state of Ohio, for the welfare of the community in Ohio. But look at the picture that Reuben Payne is painting in the minds of these Supreme Court personnel. And Louis Stokes has done the opposite. He said, well, a cop would do this anyway. If he was in fear for his life, he would walk up and grab him anyway, wouldn't he? John Terry had no chance.
10, there was the absence of assistance to this officer at this time in relation to the number of individuals involved here. There was one police officer and three men. The type of clothing also he considered at this particular time because they were wearing overcoats and the possibility that they may conceal weapons as they existed here. The sex of the subjects. I think that he had to take into consideration at this particular time that there were three agile young men that he was confronting, and he was by himself at this particular time.
He says there was 3 men, and then a second later he says, and the sex of the 3 men. What he's really saying is that there was 3 black guys and the cop. And what the cop really needs to be able to do in this situation is run up and grab them.
Under these circumstances that he was confronted with at this time.
There were no circumstances confronting Martin McFadden. He was watching from over 100 feet away. He just decided he didn't like how they looked. Thurgood Marshall thoroughly debunks that there was any case to begin with. It was just guys walking around on the street in public doing nothing wrong. But listen to how well Reuben Payne paints that picture for the Supreme Court personnel. That this was one cop confronted with these guys and they're coming at him and his life's in danger.
I believe that it is in the interest of public safety. I believe it is in the interest of the welfare of the community and society.
What does community mean at that time in our history?
The invaders are 14 Negro and white passengers on an inbound bus. They are vastly outnumbered. The armed might at the bus station waits not to fight, but to protect them from the white population. But everyone, the police, the troops, the town, knows that the riders are only a symbol. The real invader is integration. Battle lines are drawn, the defenses complete. The bus station guarded outwardly by the entire police force of the city. There are others. Around the corner, plainclothes deputies wait. Just out of sight, troops are standing.
That he have the right, based on these probable cause circumstances, to frisk this man, to temporarily detain him, to ascertain that which he has observed.
Reuben Payne is arguing that cops have rights over us, that you're not free to walk around on the street. Listen to his words very carefully. He's saying that if a cop is suspicious of you, he has rights over you. They have the right to grab you. That is the exact definition of a police state.
Since it was not based upon probable cause, we should not protect the constitutionally impermissible arrest by permitting the yield of that arrest to come into evidence against the defendant.
And to confiscate any weapons which he may find on his person at that particular time, that they are admissible in the evidence of his trial subsequently thereto.
And to search for weapons and apply it to his trial. This is par for the course. Since the beginning of our country, our government has tried to ensure that black people could not get guns. This is just another step to do it. Remember that in October of 1968, Congress will pass legislation that makes it a crime to have a gun on you unless you've got permission from the police bureau. That's called a convergence of power. Where in the Second Amendment does it say that you have to get permission from the police to carry a gun? Conservatives, this is how they created gun control.
And I am perhaps bound to indicate that the Court of Appeals has suggested in this particular case that we authorize the stopping under these circumstances where there are these surrounding circumstances for the protection of the officer's life and for the protection to the community that will exist if this is not permitted.
Listen to the argument that Reuben Payne puts forward, and this is his closing argument. He says, I am perhaps bound to inform you that this is the jurisprudence moving forward.
We should like to make reference just briefly to the decision of the lower court in this matter, where our court held in that opinion.
And now listen to Louis Stokes mention the lower court in his opening statement. There's not a rattle of an argument in him.
And I'm not going to stretch the facts and say that there was a lawful arrest prior to the frisk of the defendants. I believe it would be stretching the facts beyond reasonable comprehension and foolhardy to say there was an unlawful arrest, because there wasn't from the facts as presented. I believe, and I reiterate again, that search and seizure law cannot be applied to this particular situation, although Mr. Reuben Payne endeavored to show there was a lawful arrest. But the court cannot agree. If there was an arrest, it came subsequent to the frisk.
Why wasn't this his closing argument?
I understand that, but we have to think about your case and the preceding cases in whatever relationship may be appropriate one to the other.
Did you hear what Abe said? Abe said that he's bound by the cases before him because of the jurisprudence. Abe, you are bound by our Bill of Rights. The Supreme Court has lost its perspective. They're supposed to be the arbitrators of our civil liberties, not the case that preceded it.
Our court admitted that in all probability this will lead to abuses by the police, but then went on to say that the court would deal with the abuses as they arose before the court.
This would most certainly lead to police abuses. At that point, the Supreme Court should say, wait a minute, are you talking about the people's civil liberties? And here's the results of the courts taking on the cases as they come. There's the results. Let me put an argument forward like Reuben Payne. I feel it as though my duty to explain to you the jurisprudence of how we've gotten to this point. The Kerr case uses common law. So that's from the 1600s. But why did they invoke common law? Because the Kerr case was based on extingent circumstances, marijuana. So what happened? The big pharmaceutical industries took over writing legislation for the government, and pharmaceuticals and medication became the #1 priority of businesses to arrest people. Pharmaceuticals. That's why marijuana was demonized in the Kerr case of 1963. The jurisprudence moving forward of Kerr is Terry versus Ohio. Terry versus Ohio is exactly like Cruikshank of 1876. The Cruikshank case of 1876 stripped you of all of your civil liberties. That's where the Supreme Court ruled that your civil liberties could not be applied to you. The result is the lynching chart you see there. Now, fast forward. We use the jurisprudence of common law because the Kerrs were marijuana dealers. And the big pharmaceutical industry, William Randolph Hearst, Lamont DuPont, Andrew Mellon, Carnegie, and John D. Rockefeller, didn't want to compete with marijuana. And so for that reason, Kerr versus California happened in 1963. The results of that are Terry versus Ohio. This is all jurisprudence. Terry v. Ohio puts officer safety over your First Amendment right. Officer safety is paramount. It also invokes the idea that reasonable suspicion is the same thing as probable cause, meaning that you can be detained, which is arrested.
And though Terry is before you, we think that it goes much further than this. We think that when the state is saying that there's something called reasonably suspects, reasonable suspicion, as it is put in some jurisdictions, and they're asking this court to relax the Fourth Amendment as it is known. They're in effect asking this court to nullify the Fourth Amendment and to overrule Mapp versus Ohio.
Pennsylvania versus Mims says that you got to get out of the car in the name of officer safety. Arizona versus Johnson says that you got to get out of the car if you're the passenger in the name of officer safety. Michigan State Police versus Sitz creates DUI checkpoint. These two cases of Tennessee versus Garner and Wilson versus Arkansas are absolutely insane. Their jurisprudence is based on Terry versus Ohio. You can't shoot people in the back of the head. You can't no-knock raid someone's home unless officer safety is in question. That's what the rulings say. The jurisprudence of Terry created Graham versus Connor, that police can use objective reasonableness in how much force they can use against you, meaning any amount they see fit. If they say they fear for their life, they can shoot you. Graham doesn't happen without Terry, because DeThorne Graham wouldn't be stopped for walking in and out of a convenience store. Cortez versus the United States. They don't even have to be suspicious of you, just the circumstances that you're in. You're in a high drug area. There was a break-in over here the other day. Wren versus United States, pretextual stops. An extension of Terry versus Ohio. They're suspicious of your car. They're just stopping people because you're in a gang neighborhood. They can make up any excuse they want to pull you over. Florida versus Harris. If a dog barks, that's probable cause. According to the Fourth Amendment, probable cause is what you can be arrested for. Probable cause is now equal to a dog barking because of Terry versus Ohio. Illinois versus Gates. This case supersedes Spinelli versus United States. Illinois says that police can take the totality of the circumstances plus any confidential information, and that can create probable cause against you.
We're saying that at the point this police officer approached these men, and at the point that he lay his hands on the citizen, that he did not have the probable cause that is required. He had stated that all he had at that point was this intuitive sixth sense, and that he had never in his long experience as a police officer ever arrested anyone for this purpose. In order for this court to again take a look at are some of our basic constitutional guarantees. And I think through Terry that we look at the hundreds of people walking the street by the day, because a police officer finds himself observing a situation where he says, as he did in this case, well, to tell you the truth, I just didn't like him, and then I began watching them. And then the fact that he wants to go further. And at that point, I think we're subjecting all of the people who have this inviolate right of privacy to this type of activity on the public streets throughout our nation. Give us this reasonably suspects based upon suspicion, whatever the standard is, it's less than probable cause. The impossibility that this court has of standardizing such a subjective thing as intuition.
The problem is jurisprudence by an unelected Supreme Court. They've been based on race and authoritarianism. Unless we create an electable Supreme Court with term limits that we, the people, can hold accountable, we will live like this for 100 more years. We have about a 5-year window to overturn Terry versus Ohio. I need your help. Conservatives, I need your voice to say that officer safety is not above our civil liberties. We have to join together, no matter which side you're on, to overturn Terry versus Ohio. Thank you.